let me see, my client is a grandparent, and my client had a lot of time with the little grandson. The client raised the grandson till he was 10 years old, and then when the parents came and got involved, and now has custody of the grandson. So the parent who got custody of the grandson has now moved to another state, which that parent is entitled to do because, parent can move wherever they want with their child. But what has happened in effect is that my client no longer has visitation with the grandson, and she did have very liberal visitation with the grandson because she raised him until he was 10 years old. So we have gone to court to ask the court to turn the visitation plan into a long distance visitation plan. And what's happened is the parent who's moved with the child out of state has really been not showing up. So there was a requirement that we go to mandatory mediation, and the parent did not show up. We had the parent served. We filed a petition to modify visitation, and the parent did not show up for the first court date. So what this is causing is some problems in terms of jurisdiction. And I've talked about in the past, the UCCJEA, I always forget what it stands for, but it's the Uniform Child Custody Enforcement and Jurisdiction Act or something like that. But it details how jurisdiction works in the states, and it applies in all but one state, which I think is Massachusetts. So under the UCCJEA, generally speaking, where a child has been for the last 6 months is the place that has jurisdiction. So my client started filing motions within a month or two after the little boy moved with his parent out of state, which means jurisdiction was clearly in Arizona when she started trying to get her visitation rights changed for long distance. But now what's happened is because the mother has delayed, the mother who moved, the parent who moved, now we are just outside the 6-month range. And the court is asking me, well, why wouldn't I decline to exercise jurisdiction in this case? Because, the kid hasn't been here. The kid has been in the other state for 6 months. And that's a really good question. My answer to that question is that I think the other party has acted in bad faith by ignoring court orders to appear for court dates. And because of that, I think that she should not get the benefit of having jurisdiction where she has relocated to. That's what I think. But there's this other part of me that's thinking, okay, realistically, she's in this other state across the country, and she's not showing up. She's not abiding by court orders in Arizona. So realistically, how likely is an order of this court going to move her to action? How likely is it? And I'm kind of starting to feel like not very likely. She's not going to abide by the court order. She's already made that clear. So there's part of me that's wondering if my clients and I should just say, that we should say, yeah, judge, you're right. Or maybe you're not right, but we're agreeing that the other state should have jurisdiction. Because there's part of me that's thinking if the state where the mother has taken the child issues orders on visitation, then it's going to be easier to enforce those orders in the state where the mother is, because those orders are coming from the same state where she is. I don't know if that makes sense. So I haven't totally made up my mind on this in terms of how we're going to go with the strategy. But, it may feel like we're losing because we're saying, all right, now my client has to fight this battle across the country from Arizona in this other state. And that feels like a loss in a way. But long term, possibly, I think it could increase my client's chances of winning because that other state is going to be able to come down harder on mother. I've had experiences in the past where we have court orders from Arizona and somebody's taken the child out of the state, and law enforcement from that other state is just not recognizing the Arizona orders, or they're making us jump through all kinds of ridiculous hoops. We got to get orders registered. There's lots of rules around enforcing foreign orders. So those are my thoughts on that. I hope that helps and makes sense. It's kind of it's kind of a complicated issue. So my point is that sometimes in your cases, you got to think beyond the immediate win. In this case, I'm pretty sure I could argue and convince the judge that jurisdiction should stay in Arizona. I think I could do it because of the other parent's bad faith. But long term, would that benefit my client? maybe not. So don't just think about the immediate win. Look at the long-term effects of an immediate win on your case. Okay, yeah, and there's always something to learn with practicing law. That is for sure. And I don't know how to play chess. My husband is a chess player, but I see him. We go to the mall, and they have those big giant chess boards, and kids are playing chess. People are playing chess, and we'll stand there and watch, and he'll say to me or to himself, "Don't do that. Don't do that. Don't do that move, because then 3 moves down, somebody's going to get checkmate or whatever." And that's kind of how this is. I mean, it's not a game, but you always have to be thinking, strategy, like a chess match, and you have to be thinking 3 steps ahead. If I do X, then what is the person going to do? Are they going to do Y? And when are they going to do it? Okay, so you can't just think about right now. You have to think about the long term in the future. And I always tell you guys, remember, it's not a sprint, this is a marathon. So sometimes you might lose a battle today or tomorrow or next month, but it doesn't mean that you're not going to win the war. Okay, there's always setbacks, but always be thinking 3 steps ahead in your cases.